Mrs. FAREEN Jamal and Sanaz Golestani. They're in family law business, and they have a combined experience. Mrs. FAREEN Jamal and Sanaz Golestani. They're in family law business, and they have a combined experience. As a technical difficulty, I'm hearing myself. And Sanaz Golestani. They're in family law business. I'm hearing myself. They have a combined.
Hello again. We're here to present to you today about family law matters in real estate. My name is FAREEN Jamal.
And I'm Sanaz Golestani.
And we're both with Jamal Family Law. We together have almost 25 years of experience. I used to chair the Ontario Bar Association's family law section. And I was the recipient of the Heather MacArthur Memorial Young Lawyers Award in 2014. I sit as a deputy judge in Burlington and Milton in the small claims court. So today we're talking to you about family law matters in real estate.
We're going to take you through a few topics. We're going to first start off with just some general facts with respect to family law in Ontario. And we're going to go towards the end of our discussion. We're going to go towards mahers and the enforcement of mahers in Canada. That's an area that FAREEN and I work quite a bit in. We're very involved with enforcement of mahers in Canada. FAREEN has written a few papers on the issue, which we can share after if anyone's interested in sharing and learning about it. So family law in Ontario. So approximately 30 to 40% of marriages in Canada typically end up in a divorce. That's approximately 2 out of every 5 marriages.
First marriages.
Yeah.
For second marriages, the rate of divorce is even higher, and this is straight from Stats Can's numbers. In any separation, there really are 4 big buckets you need to think about. There's custody and access, child support, spousal support, and division of property. People get hung up on the divorce itself, but in Canada, being separated is good enough. You do need a divorce to get remarried, and a divorce will affect medical dental benefits. But for all other purposes, for Revenue Canada, for all other purposes, being separated is good enough. It's really the 4 big buckets that we think about. Today, we're focusing on the 4th bucket, property division, because that's how it relates to real estate as well as the mairie. Sometimes people confuse income issues. Income is about child and spousal support. Okay, though it's the other 2 buckets. Today we're focusing on the property bucket.
So I'm going to be focusing on the property issues between married and common law, and I'm going to distinguish between those 2. And I'm going to talk a bit about the matrimonial home. So married or common law, why does that matter? So to be considered married, a couple you have to have a marriage ceremony that's performed by an individual who had the legal power to marry them. This, for example, could be a judge, a justice of the peace, or a religious official. Now, to be considered common law in Ontario, a couple must live together in a conjugal relationship for at least 3 years. However, if the couple have a child together, whether it's by birth or adoption, you will be considered common law if you have only lived together for 1 year. Now, why does this matter when we're talking about family law and separation? It matters because the Family Law Act, which is the legislation that governs the property division and matrimonial home and all those issues, applies to married spouses only. So there's no legislated property rights for people in a common law relationship.
Relating to property.
Relating to property, yeah.
It's different when it comes to support.
Right. So pursuant to the Family Law Act, a spouse means either of 2 persons who are married to each other or have together entered into a marriage that is voidable or void in good faith on the part of a person relying on this clause to assert any right. Meaning when you're dealing with property issues and equalization of your net family property, you have to be married. So in Ontario, when married couples separate, they have to equally divide all of the property acquired during the marriage. So I'm going to take you through a two-step process to tell you how, in a simplified kind of method, we determine what the equalization payment is and who owes who what. So to do this, each spouse calculates their individual net family property. So step one of that is you generally, I say take a snapshot, okay? When you came on the date of marriage, what did you own? What did you owe? So your assets and debts. At the date of separation, which is an important date because that's the date that we use to value, again, your assets and debts. I say, what again, take a picture of yourself on that one specific day. What did you own and what did you owe? So you calculate the value of your property less any debts on the date of separation, and then you subtract the value of your property less any debts on the date of marriage. If any property is owned jointly, you only consider your own percentage of the interest when determining the value. Step two is the spouse with a higher NFP, the higher net family property, then pays the other spouse half of the difference. This is the equalization payment. I'm going to take you to an example. How to calculate equalization payment. In this case, when we take the calculations and we say, okay, spouse A, on the date of, when we consider your assets and debts on the date of marriage and your assets and debts on the date of separation, at the end of the day, your net family property is about $80,000. We do the same process, step one and step two for spouse B. And we say that we determine that the net family property of that spouse is $30,000. So you subtract the $80,000 from the $30,000 to get the $50,000 value. The $50,000 value then gets divided in half, and the equalization payment of the spouse who has the higher net worth then becomes $25,000. So in this case, spouse A would pay spouse B $25,000 as an equalization payment. And that's the simplified method of how to divide property and how to determine equalization between married spouses.
Well, the only thing that I'd add there is an equalization payment is a cash payment. People sometimes think that they're getting half of a property or half of a business or half of a car, and you're not. It's a cash payment. How it gets funded is a different discussion than what the number is. The other thing is that property in Canada is provincial. So Ontario is an equalization province. We do date of marriage, date of separation. Other provinces do it differently. So sometimes I have clients saying, oh, but my cousin in Alberta, and I say, yep, they have a different scheme there. Ontario is an equalization province. This is how we do it here. And so that's important to bear in mind. In other provinces, while we're talking to you about what happens with married and common law relationships, married and unmarried partners, in other provinces, they have included unmarried partners into their equalization scheme. In Alberta, right now, as we speak, they've raised legislation to include their unmarried partners in their property division scheme, like we have in the equalization. Ontario has not taken that route. Okay, there was a case called Walsh and Bona. It's a Supreme Court of Canada decision, and in Walsh and Bona, they said these people chose not to get married. Choice is very important. So because they chose not to get married, they chose not to have this property division regime.
Exactly. So it takes us to what happens to common law couples in Ontario. So normally, if a property is owned by the individual who holds title, if the property is owned by the person and you're the only person on title, it's distributed on that basis. There's no net family property calculation or equalization payment that's contemplated for common law couples. However, if you were in a common law relationship and you believe you should be entitled to an interest in compensation for any contributions made to, whether it's the acquisition, preservation, or maintenance of a property, it doesn't mean that you don't have any options or you don't have any rights. There are options for you and equity, and those kind of come into different, I'm not going to get into it today for the purposes of this presentation, but you get into arguments of whether it's a joint family venture, constructive trust claim, a resulting trust claim, and you go into the kind of the trust areas of law to get your interest on. It's a more complicated process, and it generally will involve litigation because, again, the person who is on title generally does not want to share their asset.
And it's a complicated area of law. I mean, the Supreme Court of Canada gave us a decision called Curran Barano. If this is your situation, read the case. It's a tough case to read. It's a little bit like bedtime reading because it puts you straight to sleep. It's a difficult case. It's a difficult issue, but that's the framework with which we use in Ontario still.
The Family Law Act, it deals with what we can call special assets, which is the matrimonial home. So what is the matrimonial home? So it's a home that a married couple lived in just before they were separated. There can definitely be more than one matrimonial home. For example, some families have a house and a cottage, and based on the use of that property during the marriage, it could be coined as being defined as a matrimonial home. The difference and the unique aspect of the matrimonial home is neither you nor your spouse is allowed to sublet, rent, sell, refinance, mortgage, or place a line of credit on the matrimonial home without the other spouse's written permission.
Yeah. You could have lived in one house for 50 years and live in one house for 6 months. The house you live in on the day you separate, that's your matrimonial home.
So what do you need to know about the matrimonial home? There's this equal right of possession. So the matrimonial home, again, is treated distinctly from all other property under Part 2 of the Family Law Act, which again only applies to married spouses. Unmarried cohabiting spouses do not have the same right to possession of their home. It doesn't matter which spouse is entitled to the matrimonial home. You each both have an equal right to reside in it. You can't be kicked out of it. Neither spouse can prohibit the other from living in the matrimonial home until or unless a formal separation agreement is made or one spouse is granted exclusive possession of the matrimonial home. So again, I put a little warning here because even a marriage contract made prior to the marriage will not be binding if it is eliminating one spouse's right of possession to the matrimonial home. So I just want to talk a little bit about what is an order of exclusive possession. So while we say that you have equal rights to possess, to reside in the matrimonial home, there is an exception. So an order for exclusive possession it's a temporary time-limited court order that allows only one spouse the exclusive right to stay in the matrimonial home without the other. So a lot of times after separation, especially when children are involved, both parties don't want to leave the home because you can't just get up and take the kids with you, right? There's legal implications for that if you do that. So what ends up happening is parties will cohabit, separate and apart, but still living under the same roof. In situations where there's high conflict, where there's concerns with respect to domestic violence, abuse and all that, you do have an option to try to obtain an order to obtain exclusive possession. So when you get an order in your favor for exclusive possession, the other spouse will be legally required to move out of the matrimonial home and forced to live somewhere else. It can be granted to a spouse even if he or she is not registered on title to the matrimonial home. So if you had owned the home and you're the one that's on title and you're the legal registered owner of the home, it could easily be that a court order is obtained, making you leave the house with your spouse still residing in the home. It does not provide the spouse permitted to stay in the home with a right to legally sell or dispose of any property or the home itself, and it does not provide you with the right to change the locks, and it does not impact property ownership rights whatsoever. So to obtain what the court considers when trying to determine if the court will grant order for exclusive possession is they look at what's in the best interest of the children, any existing orders respecting family property or support orders, the financial position of both parties. For example, when you have a stay-at-home, one partner who's a stay-at-home caretaker for the children, and the other one who has the financial means to earn an income and is the income earner of the family, they will have the ability, they're more likely to have the financial ability to secure alternate accommodations for themselves. They will look at any agreements between the parties, the availability of other suitable accommodations. For example, if your spouse has her family or a close friend or someone that they could reside with within the area, and whether there has been any violence committed by a spouse against either the spouse or the children. So who owns the matrimonial home? So a big question that's often asked is, but I owned the home before I met my spouse. Why is she or he entitled to share in the value of the home? So again, it goes back to the idea that the matrimonial home is a special asset in Ontario, and it doesn't matter if you owned it before or not. So once you and your spouse got married and your spouse moved into the home with you following the marriage and you reside in the home together until separation, this home automatically becomes the matrimonial home. For a matrimonial home, in this situation, what happens is you lose the date of marriage deduction. Back to the equalization calculation that we did in the beginning of this presentation, when I said take a snapshot of yourself on the date of marriage, what did you own and what did you owe? Applying that example, you owned a home, you and your partner got married, you lived in that home. The home is registered under your name, and on separation, you still continue to reside in that home. You do not get the benefit of deducting the value of that property on the date of marriage in the calculation for equalization. So the total value is shared. This can have a big effect, obviously, on the amount of the equalization payment that is owed. And Section 5(6) of the Family Law Act provides an exception to this rule. And FAREEN will talk about that briefly.
Yeah. So when you think of the biggest issue with the matrimonial home is the fact that you lose the date of marriage deduction. And that can be quite significant. If you had brought in $100,000 worth of bonds or cash or an investment property, another property, if you had moved homes during the marriage, so it's a different property, you get a date of marriage deduction for that asset. This is an anomaly of the Family Law Act, in my opinion, and we've been lobbying to abolish this deduction. But right now, as it currently stands, you lose your date of marriage deduction unless you fit under Section 5(6) of the Family Law Act. There are a few. You have to be able to prove unconscionability, not just unfairness. In British Columbia, they have an unfairness standard. In Ontario, we have an unconscionability standard, which is much higher than unfair. So if it's unfair, courts say, well, it's unfair. The Act still says it has to be unconscionable for us to override that. If the marriage is less than 5 years, this is one way to consider a Section 5 sub 6. If there are other exceptions like that, they are rare because it has to be unconscionable, not just unfair. But if that is your situation, give us a call. Let's see if we can assist you.
So then the other thing that comes up a lot of times is, but the home was gifted or inherited to me before marriage. So any gift or inheritance that a spouse got during the marriage is not usually included in their NFP calculation as long as the spouse has the gift or inheritance at the date of separation. So it's kind of a tracing exercise. Let's say, for example, you receive an inheritance and you use that money from your inheritance to renovate what becomes your matrimonial home. You lose the ability to exclude that inheritance as a result. So again, I give a little warning here. However, if the gift or inheritance was used to buy or help pay for the matrimonial home, it is included in your NFP. In other words, you will no longer be entitled to exclude the gift or inheritance if it's used towards the matrimonial home.
You lose the exclusion.
Right. If the gift or inheritance was before the marriage, the growth from the date of marriage to date of separation is what's subject to equalization. And again, funds traced to the matrimonial home lose their exclusion. So that again goes back to the inheritance example that I gave earlier.
So if you get a gift or inheritance and you pay off your mortgage, for example, you just lost your exclusion. If instead you took that gift or inheritance and you put it in a mutual fund or some kind of investment, you can still exclude that asset. So you want to be mindful about where you're putting those funds.
And often what we recommend is if you're anticipating getting a gift or inheritance or anything that during the marriage, what you want to do is you want to not commingle it with joint funds either, because that also provides a complicated tracing exercise that can be costly. So you want to keep it separate. You get an inheritance, put in a separate account.
Yeah. If you commingle it, technically you've gifted one half to your spouse. And if you use the funds, you go on a vacation, it's gone. You have to be able to trace its existence to an asset on the date of separation. Okay, enforcing maher in Canadian courts. We have spoken about this quite a bit. So if you have some questions about maher, we actually wrote a paper for a family law conference called the Summit a few years ago. We'd be happy to share the paper with you. We did a review of all of the case law across Canada that had involved maher. So we'd be happy to share it with you. Email Sanaz and we'd be able to give that to you. So maher or mehrier is spelled different ways in the case law. It's typically called maher, M-A-H-E-R or M-A-H-R. And as most of you are of Iranian descent. I think most of you already know what it is, but for those of you who aren't, it's a Muslim tradition in which an agreement is entered into prior to marriage for a sum of money that the groom promises to pay the bride in the event of a marriage breakdown or death. I should tell you this, women in the Muslim tradition had property rights well before their English counterparts or their Western counterparts. Because of this, they could own it in their own right. Sometimes it's confused for dowry. It's not dowry. Dowry is an Indian tradition that a father of the bride pays to the groom. Maher is different, and Canadian courts now understand it. I think there is a better understanding of what it is. And so it's different than a lot of the other things that it is confused for, dower or dowry. But the maher agreement reflects the inherent purposes of easing financial and social inequities between the husband and wife. In many Muslim traditions, I think people are sometimes surprised when they realize that women actually have, a lot of property rights, a lot of equality, and maher is one of the ways that this is demonstrated. There is a maher prior and a deferred maher. And again, this is different from tradition to tradition, because while we say Muslim, it's, whether you're in Indonesia or you're in Iran or you're in South Sudan, it's different in how they apply this. Okay, the maher is not considered the settlement of all future financial dealings between a couple. A maher is a right in personam. So in Canada, maher is considered a contract. It's a contractual agreement. Frankly, marriage is a contract. In Islam, in the Quran, marriage is a contract. And I think this is confused because in the Catholic or in Christian traditions, marriage is a sacrament. And for a long time, you actually couldn't get a divorce. A divorce was against public policy. And then there was a whole bunch of shaming around it. In Islam, we've never had that. Marriage and divorce are contractual. You can get in and out of them. And in that sense, that's the way maher has been treated. So maher is simply a contract between two consenting adults. So how have Canadian courts looked at it? Now, this is one area where, first of all, I should say Canadian courts treat it like any other contract. So they look at, has there been formal validity? Did they understand the contract? Has there been an exchange of financial disclosure? Did they know what they were signing? Was it voluntarily entered into? Right? If those are met, and if they understood what they were doing, then a contract is upheld. Okay, it's not against public policy, but there are some areas in which terms of the contract are questioned. So, for example, under some Muslim schools of thought, if the wife seeks the divorce, then she forfeits her right to maher. Okay, unless she does so with cause by proving that her husband is at fault. There's a difference of opinion between scholars between when a woman forfeits her right to maher. In Ontario so far, understand that all of the Canadian jurisdictions are no-fault divorce jurisdictions. So we don't look at fault. It doesn't matter who left the relationship. It doesn't matter if there was adultery. It doesn't matter. We're no fault. We've stopped looking at those shaming, blaming issues. So Canadian courts enforce maher agreements irrespective of who initiated the divorce. Because typically the maher agreements don't contain a reference to that specifically. Okay? We haven't seen that yet. There has been a division in Canadian courts about the enforcement of the maher. They aren't always enforced, and it comes back to the contractual validity issue. The challenge has been enforcing Canadian contract law while still remaining sensitive to cultural and religious traditions. The first case, actually, it was Brooker and Markovitz. It was a Jewish case about the get. And since that went all the way to the Supreme Court of Canada. And since they enforced that, they said, initially courts were saying, we're not getting into the religious thicket. We're not getting into that. But then they have shifted and they've said, we need to be able to be sensitive to cultural and religious traditions and still enforce their contracts. And so that's how maher is enforced. It's in addition to the equalization. The scheme that Sanaz talked about, from the date of marriage to date of separation, and we equalize the growth, maher is over and above that, okay? Because it's in addition to the support claims and it's in addition to the property division. When you look at cases on whether or not they're enforcing maher, when we looked at the trend of cases, part of it is the quantum that is claimed. When you look at maher agreements that are entered into in Canada, they typically tend to be $50,000 or less. When they are $10,000, $20,000, $25,000, courts have enforced them in addition to property division. When you look at maher agreements that have come from Iran and places like that, the amounts are staggering. They are very substantial. Typically, it's the Azadi coin. It's pegged to a gold coin, but the amounts when you convert them to Canadian dollars are staggering. So in those situations, courts are saying, well, when they entered into it in a foreign jurisdiction prior to coming to Canada, they hadn't considered that Canada was going to give them a 50-50 division. So we can't enforce this contract with respect to maher because they hadn't considered the entire situation. When the maher agreements are formed in Canada by Canadian residents, or not, even if they're just formed in Canada, they say they thought about their property division before they did it. So they've already contemplated the bargaining in addition to the default divorce laws with the expectations of Canadian enforcement. Like all domestic contracts, we've talked about this a little bit, it depends on the precise wording of the maher, the circumstances when it was executed. Was it, minutes before the actual wedding ceremony? Was the first time they become aware of it? Is there duress? Is there disclosure? If this is something that has been bargained over time, if there has been changes in the bargaining, if they're aware of it, then they are enforced. So they're looking at any facts that would suggest unconscionability. In 2011, the Ontario Court of Appeal in Canis and Noormahmed confirmed that maher is indeed enforceable in Ontario. More recently, again, in a more recent case, we call it Bakshi, proverbially, the courts have looked at the issue again. Do we include it at the date of marriage and the date of separation when we're looking at the equalization analysis? What does that mean at the end of the day? Is it still enforceable, or is it still a contract we're considering? And by and large, courts are saying, yep, they are valid marriage contracts under the Ontario law. And this continues to be confirmed as valid and binding. In Canis and Noormahmed, it was a $25,000 maher that was enforced. The BC court more recently refused to enforce two maher agreements in 2012. And Yar was also refused, but was subsequently appealed. The BC Supreme Court in Delvarani did not enforce 3,000 Bahar Azadi coins. This was approximately $750,000. This is what I'm saying about them being quite substantial. The court did not accept that the husband agreed to such a large amount of money in addition to his obligation under the British Columbia division. So they refused to enforce the maher on the grounds of fairness. In Iranian courts, so this is how the Iranian maher is litigated. In the British Columbia decision in 2011 of Sanghi and Sanghi, if anybody has an Iranian divorce, get this case, because Madam Justice Gray was excellent in reviewing all of the law. She recognized that in Iran, the reason that gold coins were referred to was because it was a period of fluctuation in the value of the Iranian currency, and with what's happening in the world right now, there's horrific devaluation of the Iranian currency, perhaps one of the worst in the world. But the gold coin was referred to as the Spring of Freedom gold coin, the Bahar Azadi. And in Iran, there are no matrimonial laws with respect to division of property, payment of spousal support or child support. People call it alimony, but in Canada, we call it spousal support. And the maher provides financial security for wives in a legal regime which didn't have this otherwise, and where they wouldn't otherwise be financially self-sufficient upon the breakdown of marriage. So she really does a very good analysis of that, of what happens in Iran. And she recognizes that in Iran, even if there is a maher agreement, the Iranian courts sometimes readjust the maher based on an ability to pay. And they don't just look at the husband, they look at the husband's father and other things that we don't look at here in Ontario. So conflict of laws. So when we look at equalization or any property division, the law that applies is where the parties' last common habitual residence is. Where did they live when they separated? That is the law that will be applied. So even if you start an action in Canada, you can apply Iranian law if the last place that they lived, their last common habitual residence, was in Tehran or somewhere else in Iran, okay? And so it'll provide that the property rights of spouses will be governed by the law of the place where they last resided. Even if Ontario assumes jurisdiction, that doesn't mean that the law that's going to be applied necessarily is Canadian. Okay. We move to the law of Ontario if there's no place where the spouses had a common habitual residence. There are principles of validity of contract that need to be enforced. And so this is where people start to think about marriage contracts when it comes to the matrimonial home issue, not with respect to possession, but with respect to having a date of marriage deduction, or with a maher. That's another marriage contract. In all of these situations, courts are looking at what we call formal validity. Okay, was it signed? Was it dated? Was it witnessed? Then they look at other circumstances with respect to formation. Were the parties able to negotiate the terms? Are each of them of sound mind? Do they understand the legal consequences? Was this made in contemplation of a separation? Did they, was there financial disclosure? Was there duress? Was anybody under undue influence or forced into this? Was it in any way involuntary?
The major thing that for a marriage contract, aside from maher, is I just like to always stress this to people, because people come the nth hour, right, a week before their wedding, and they say, oh, I need to do a marriage contract, I need to get this signed. A lot of lawyers will actually not agree to do it under those circumstances, because one of the major issues is you have to give the other side time to negotiate the terms. And it could be considered duress based on the timing that the agreement is signed. So, if the agreement is signed the day before the wedding, well, had the other spouse decided not to sign it, what would have been the consequences? Would the wedding have been canceled? All those kind of requirements need to be kind of checked off. So if we always recommend, especially now with people getting married at a later age, having more assets, more wealth accumulated on your own, it's definitely recommendable to do a marriage contract, but give yourself and your partner enough time to negotiate it, so you can come to, you can provide the disclosure that you need, and you can negotiate the terms in advance, well in advance of the wedding.
Yeah. Typically, we say if you want us to give you independent legal advice or ILA on a marriage contract, it needs to be at least 1 month before your marriage. So we expect you to come well before that, so that we can exchange the disclosure, negotiate the terms, make sure that there's fair bargaining, and then enter into the agreement at least a month before your marriage. So that's our presentation for you. I understand that some of you have some questions.
Yes, we do. Thank you for a great presentation, guys. A few questions has been popped up. We start with one of our colleagues. He's asking regarding equalization. If the process of divorce takes 7 years, is the calculation of the equalization different?
In Ontario, so it depends where you live. In Ontario, no, because we take your date of marriage and your date of separation, and we equalize the growth. So it's the date of separation. If you won the lottery, lost the lottery in between, nobody cares. You win the lottery, lose the lottery afterwards, nobody cares, because it's only those two snapshots that we're looking at. There was a case that we took to the Superior Court of Justice where the property in Iran had devalued so significantly from the date of separation to the date of trial. And we tried to say, Your Honor, this is unconscionable. It's more than unfair. So, with what he's paying. And the courts were not persuaded. They said, no, it's unfair, but it's not unconscionable. So it doesn't matter how many years after separation. They still just look at the date of separation.
If the gifts are still, if there are gifts, are they covered to cash? What happens to the value of all gifts mostly received from the other side of family?
So gifts, you want to do one question? Gifts, no matter who they're received by, if they're received during the relationship, are excluded assets. Okay, but they're excluded if they exist at the date of separation. So you need to trace them. So if you receive them in cash and you put them in a mutual fund, or you buy a car with it, or you buy whatever you buy with it, you have to trace it to an asset that exists at the date of separation for it to be excluded.
Yeah. You're not entitled to an exclusion unless the asset exists at the date of separation. Whatever the exclusion is, it's not just gifts and inheritance that's excluded. There's settlement funds from insurance
damages. Yeah, if there was a
excluded.
personal injury. The other thing, though, is gifts from the other side's family doesn't matter. It's still a gift that's excluded. The only gift that is not excluded is a gift from the spouse. So if your husband gives you a gift on your 10th wedding anniversary, that's not excluded. That has to be included. But if it is a gift from his parents or somebody else, it's an excluded asset.
Okay. For the answer, what happens if separation or divorce agreement does not talk about the maher agreement and it was already executed?
If you've already entered into a separation agreement, you have to check what the terms are. If the terms say this is a full and final settlement of all issues, then it is possible that that also includes maher. So then it sounds to me like you forgot to raise the issue, or your lawyer forgot to look at it. It depending on the terms of the agreement, you may have lost the ability to raise it. I couldn't speak in a vacuum without looking at the actual agreement. We are very careful when we do our cases to make sure we ask, is there a maher? Is there something else we need to include?
Okay. Talk about prenup or a contract before marriage. I don't know how to question that, to be honest with you. Can you give us a bit of an insight on prenup agreements?
Sure. So, I mean, we call them marriage contracts. So what would happen is, again, like I said earlier, if it's highly recommended to do this because it can avoid a lot of potential legal costs and litigation. It doesn't mean that just because you have a marriage contract, the other side won't try to set it aside maybe later when you're trying to separate. There is that issue at the time. But what we say for marriage contracts is come again well in advance of your anticipated wedding day. You can protect your assets. The only thing we can't do is, like I talked about the matrimonial home, you can't put a term in the marriage contract saying that if we separate, spouse B has to leave the matrimonial home. You have an equal right to possession. That's not an enforceable term of a marriage contract. But if you're getting married and let's say, you're coming in with a home that you and your partner are going to reside in, who knows how long you're going to reside in there. You have significant equity in that property or in that asset. You have significant investments. You can come up with terms and an agreement to say that what I come in with is mine and what we accrued jointly together during the marriage possibly could be, split or shared, but you won't get what I have. I won't touch what you have. And spousal support issues can be addressed in a marriage contract. We do not address custody and access issues for, whether if you're going to have children, we won't say that parent A will get sole custody of the child if they separate. That's not an enforceable term in court, even if it's put in a marriage contract. So issues related to children of the marriage will not be addressed in a marriage contract, but they will be addressed at separation based on what would be in the best interest of the children.
Okay. On the earlier question where we asked, what happens if separation or divorce agreement does not talk about maher agreement and was already executed? They're saying, what do you mean by excluded?
I think there might be a confusion here. So if the maher, it depends on the terms of the agreement, whether or not it's been already included as all other issues that, this agreement covers all other issues and we won't come after each other for anything else. That's different than excluded. When we talk about an excluded asset is typically a gift or inheritance, or if there's been personal injury damages, there are other excluded assets that are excluded from the equalization, excluded from the property division from the date of marriage to the date of separation, unless you have a marriage contract. So the question earlier about a prenup, we don't use that. I mean, you can use the language, but whether it's a prenup or an antenup, in Ontario, we call them all marriage contracts.
Okay. One of the colleagues asking, could a spouse request alimony and mehriye in Canada?
So alimony is spousal support. Yes, you can claim that. And mehriye is exactly what we've been talking about. Yes, you can claim it, but courts are divided on when they will enforce it. They will enforce it as a contract, but it depends on the terms of what all the terms we were talking about, whether or not the parties understood the terms of the contract when they signed it, how soon before the wedding, was it the day of the wedding, the first time it's raised? I mean, how soon before the wedding were they bargaining these terms? So that's exactly what we've been talking about. Yes, Canadian courts do enforce mehrier.
Okay. Tina, does it apply to properties you own in other countries like Iran?
In Canada, when we look at equalization, we equalize your worldwide assets. So when you do a prenup or a marriage contract, even if you do it in Canada, it can deal with your worldwide assets in the same way.
I see. Okay. About that earlier question that I had, I think I was referring it to a different one, so that was my bad. They were saying the exclusion in terms of the gifts. If the gifts are still, they're not covered to cash, what happens to the value of the gifts mostly received from the families or the other side? That's what they meant by exclusion. So maybe I kind of read the wrong.
I'm going to just trace it back a little so we're not getting confused.
So originally, one of our colleagues asked if the gifts are still there, not covered to cash, what happens to the value of all the gifts mostly received from the other side of the family, right? So he's asking, what do you mean by excluded?
Okay.
When you
when we talk about exclusions, it's under Section 4 of the FLA. There are certain assets, properties that are allowed to be excluded when determining your net family property. Now, when we talk about your net family property, again, I'm going back to the beginning of the presentation when I said, take a picture of yourself on the date of marriage and the date of separation. What do you own and what do you owe, right? When you determine the increase in the value during that period of time and which partner has the higher net worth, that is how we determine who owes who an equalization payment. Okay. Now, Family Law Act comes and says, okay, you have to share as a married couple. If you don't have an agreement or anything like that, the higher net worth spouse has to pay the other one an equalization payment. But we will allow each spouse certain properties to exclude from this equalization calculation, meaning you are not required to share this in this equalization payment and determining the equalization payment. And those exclusions are what we keep talking about, which is gifts, but you have to be able to trace that to something that exists at the date of marriage. Inheritance, if you've received it, again, it has to be existing at the date of separation. Settlement proceeds from damages and
yeah. So the excluded assets are windfalls. The parties didn't work for them. They haven't increased their growth and their value from their hard work. This is just a windfall that they got from their family or somebody else who gifted it to them. So the courts say the gift is for you. You can exclude it. It's for you and only you. You don't have to divide the value.
It's kind of anything else, I think. Are the first-time buyer that has brought money from Iran in order to purchase a home in Toronto. This money belongs to her family back home. In case there is a separation, she doesn't want to share it with her husband. What could be signed prior to the purchase?
So two things come to mind right away.
Mm-hmm.
The first is do a marriage contract. Clearly set out what the intentions and expectations are with respect to this money. That this, the marriage contract is both parties understanding where these funds came from and when it's going to be repaid. The other is if this doesn't happen, when we have a patriarch or a matriarch come to us and say, I'm about to give my child this money that they're going to put into a house, what do I do? We say, get a mortgage against the home. Make it really clear, not just a loan agreement, go as far as getting a mortgage against the home. The problem that you have if they separate after the fact is the test that the courts use is likelihood of repayment. What is the likelihood that this money will be repaid? Have they been paying money back already? Are they going to actually pay the money back? Or is it just a gift that they're going to allow them to have? This is the test that is looked at.
If a husband or wife own like 5 properties in different locations and live in all of them, like 2 weeks in Florida, summer cottage, winter ski property, and other ones. How will court treat this in a case of divorce?
There's a lot of factors to consider, but it's really dependent on the use of the properties. If everyone goes to the cottage every summer as a family and they live there for a period of time or come and go and there's a routine in there, the kids go, and it's treated for any intents and purposes like the matrimonial home that they regularly reside in, it could be considered a matrimonial home and subject to the same laws under Part 2 of the FLA. So it's really fact specific. It's really, and I know a lot of people think lawyers don't want to give a straight answer, but there's so many different criteria that are considered in it. In a situation like that, there is grounds to say that it could be considered, they could all be considered a matrimonial home, all 5 properties.
All 5 are matrimonial homes, and you lose the date of marriage deduction on all 5 of them. If you use them, live them, if it was an investment property and it's rented out, that's different. That's not a matrimonial home. You're not using it to live in. But if you're, 2 weeks in I think you said there was 2 weeks in Florida or something, right? So if that's the case, it's not they're all matrimonial homes.
I mean, there's arguments against it as well.
How do you prove that if I have 5 homes and I'm living in different properties, how do you determine which one is matrimonial? I always thought that one house is matrimonial.
That is a common misconception. You can have more than one matrimonial home. And if you have a cottage that you visit often, you have at least 2 matrimonial homes. And so in this case, if all 5 homes, one is in Florida, one is a summer cottage, one is a ski chalet, and if they're living in them, they're not renting them out, then all 5 are matrimonial homes. You can have more than one matrimonial home. That is a common misconception.
So as long as they're just vacant sitting there, they're not matrimonial homes, right? You have to show proof that you live in the property.
If they are rented, they're not a matrimonial home. If they are vacant, but you reside in them even 2 weeks, semi-regularly, it's a matrimonial home.
Interesting. We learn every day.
We're happy to help.
What's that?
We're happy to help.
In case of separation down the road, what document can they sign prior to purchase in order to protect the family funds?
I think this was the question you were asking earlier, where I was saying, do a marriage contract.
Yeah,
do a marriage contract really clearly identifying what the use of the funds are, or at the very least, get a mortgage against the property, because the test is likelihood of repayment or what the intentions and expectations were.
Okay. It seems we ran out of questions. Thank you guys very much for an amazing, informative session. There was a lot of questions answered. Your time is well appreciated. Sorry, at the beginning we had a bit of technical difficulties, but it kind of was a great chat, great seminar, and thank you guys very much. We have actually 47 minutes, another 10 minutes to go, but I don't think anybody's asking any question. Hold on, I have another one. What happens if one person is on the title and he didn't mention that he's married, and you listed it and sold it? Good question.
Don't do it.
Yeah.
You must ask.
Seriously, what happens? So that's a very valid question.
Liability.
What's that?
Liability.
What does that mean? Who's going to get charged here? Is
We've
it
had
the involved is going to get in trouble? I would think he would be in a way.
the real estate lawyer needed to ask the questions, because there's a spousal consent that they have to sign.
Yeah, but what if, just like you mentioned, there's any evidence that I called the agent in and I'm not telling I'm married. She's moved out. She's in Tehran or whatever, and I sell the house and it closes. I didn't do anything wrong. I'm not going to go and say, hey man, are you married? Are you divorced? How am I protected, and how is that person protected?
So there is actually a question. There's actually a declaration that they have to make. It's a sworn declaration about whether or not they have a spouse. There's a spousal consent that needs to. So any real estate lawyer.
When we do, yes, we do. But if I go to a home and the guy is single, like I don't see anybody, then I'm not going to question, what is your wife?
Are you talking as an agent or as a lawyer?
As an agent. Right now, my colleagues are asking these questions.
The real estate lawyer. That's because the real estate lawyer is the one that's doing the closing of the sale.
Oh, I see. So the lawyer is going to be basically in trouble.
Right. Which is why it's the lawyer's obligation to ensure that they they ask those questions, and that's FAREEN was saying there's a consent, there's a spousal consent for selling a matrimonial home. They have to say it.
We sign too, but we have to know. Otherwise, if the guy is lying to us, not disclosing, there is no protocol for an agent to discover what's going on, right? So
sometimes when it's a bank who has done the mortgage and the financing, and then they're doing refinancing, and there has been a shift, and so now the bank could have obligations and liability because you knew there was a spouse. You should have known that there was a spouse, or you should have asked those questions. So it's an issue of liability, but a liability typically for the lawyers.
I see.
Okay.
What else we got here? In prior question, if rented one after they own used, what will happen? I'm not understanding.
I think this is a matrimonial home. So the matrimonial home is the home you live in on the day you separate. So if you lived in a home for 50 years and then you rent it out and move into another home, it's no longer your matrimonial home. The matrimonial home is the one you live in on the day you separate. So if the house is rented out when you separate, you're safe.
You may want to consider that when you're coming in with an asset and you're about to separate, or you want to separate. If this is a home that you brought into the marriage, you may want to go live with your spouse for a few months in a rental property, rent that property out, and save yourself the matrimonial home.
You know, because if you had brought it in as an investment, as mutual funds, you'd get a date of marriage deduction. So this is an anomaly in the law that, frankly, we think needs to be changed. We have been lobbying for change, and that's why we say, look, if it was any other asset, you'd get your date of marriage deduction. How is it fair that you lose the date of marriage deduction just because it's a matrimonial home? So it's unfortunate, you know.
Let me flip it around. So you buy an investment property as an investment, and then you kind of move in. Would that make it into a matrimonial automatically, right?
If you live in it on the day you separate,
it's a matrimonial. It's matrimonial. Okay, that's easy to follow through. All right. That's pretty much it, guys. I think everybody's thanking you guys very much, and very great session, very informative. Thank you very much for your presentation. All right.
Not at all. If you have any further questions, feel free to reach out to Sanaz or myself, and we'd be happy to help you.
Definitely.
For having us.
With that, I think we're going to end the session. We have 8 minutes, but I don't have any questions. If you guys want to add anything to the presentation, feel free to do so.
Thank you for having us.
Anytime. Please don't forget to ask people to join PICRA. We are trying to increase our membership, so spreading the name would help, definitely. It will help everybody, right? It's a great networking platform, and it's very informative for all parties. Okay?
We will.
All right.
Have a great weekend.
Take care.
Enjoy your day.
You too. Bye.
Bye-bye.